Is the ChatGTP contract worth anything in court?
Judges really do not look favorably on lawyers who are cutting corners and using AI tools and then not checking the work.
Seems like you might be sitting on the ticking bomb, like for the future.
Yeah, and we have definitely seen a few of those, unfortunately.
Going off.
Yeah, and going off in a way that ends up costing founders a lot of money to buy back portions of their company.
What do you think is going to happen with the legal space and AI? Like, what's your prediction?
We will probably see junior roles being replaced with AI tools.
What would you say is the biggest lie founders believe about legal? Over 60% of startup failures involve some kind of legal dispute, whether it's co-founder fallout, IP theft, or investor lawsuits. Today, we're speaking to a startup lawyer who's seen it all, the good, the bad, and the legally catastrophic.
Yeah, today we're talking to Gretchen Lennon, a former city lawyer who left her global firm to build a boutique practice for startups and scale-ups. Her 10-person team works fully remote, and Gretchen now lives in Switzerland, splitting her time between helping founders and skiing or mountain biking in the Swiss Alps. I am very jealous of that.
Well, welcome, Gretchen, and thanks so much for joining Building Great Tech.
Thanks very much for having me. It's great to be here.
Awesome. We spoke a little bit before the interview, but I still would love to cover like a little bit. What kind of clients do you work with?
Sure. So we're industry agnostic. I think that's the first thing to note, but we typically advise clients across the sort of very early stage sort of founder journey through sort of seed, Series A up to Series B, kind of startups and scale ups really. And at some point in a kind of scale ups journey, they will have probably outgrown our small team's resources and capacity. And that's the point at which, we're very happy to see them fly off and be looked after by a much bigger law firm. But yeah, right from the very beginning of the journey up to that point, really.
So at every point, really.
Yeah, exactly.
Amazing. And is it UK law? Or is it international law? What do you guys specialize in?
Yeah, at the minute, the whole team we are UK qualified lawyers or English qualified lawyers only. At some point in the long term plan, we are hoping to add more international lawyers to the team. But yes, we typically advise UK companies only at this stage.
Amazing. What would you say is the biggest lie founders believe about legal?
Oh, that's a great question. I think something that we encounter quite often with very, very early stage founders is the idea that they can kind of DIY a lot of their legals themselves. And whilst it's not completely untrue for some sort of, maybe low stake or low value documents, and certainly there are some really great kind of like DIY off the shelf platforms like legal document providers where you can kind of just get a kind of one size fits all template and roll it out and away you go. Quite quickly as companies grow and as the stakes get a little bit higher, the values of the contracts get higher, and maybe the terms that they're negotiating get a little bit more complex. It's at that point where, unfortunately, the sort of the lie that founders might tell themselves that they don't need to speak to lawyers, they can do it themselves. That's when it kind of really kind of comes back to bite them.
Right. So when do you find founders usually come for legal advice? Is it like before or after it's too late?
I have definitely seen it on both sides of the fence. I mean, obviously, before it's too late, it's great. We get to sort of, step in, build a great relationship with clients and help them navigate all of the different stages of what they are going through on the kind of company life cycle and help them avoid any sort of major legal pitfalls. Of course, we've seen it, on the other side as well, where founders have unfortunately maybe come a little bit too late and we are either trying to help them unpick documents that, template documents that they just found somewhere, whether it's online or maybe they, got sent it from a friend or whatever might be the genesis of it. And it doesn't quite serve the purpose that they need, but they've inadvertently, signed up to terms that they didn't quite understand. So yeah, we've kind of approached these kinds of things from both sides. But I would say from the very, very early stage, like, founders, particularly those who are not first-time founders, anyone who has a bit of experience maybe working with early stage companies before, you can kind of do quite a lot yourself in the very early stages. And indeed, money is tight, let's be honest. Like bootstrapped companies, they don't have the money to go out and sort of engage lawyers, resources are limited. So you can absolutely get through quite a lot with just sort of these kind of template documents. But I would say the point at which you probably do need to be speaking to a lawyer is either when you are about to negotiate your first funding round, where any of the terms of the funding round are anything more complex than just money in exchange for ordinary shares with no other frills. So that tends to be where maybe it's a VC-led funding round, or perhaps even just maybe it's angel investors, but they're asking for certain terms over and above just the ordinary shares. Other times, I think when it's really important to speak to a lawyer are maybe for example, if you're a solo founder and you're bringing in a co-founder, or maybe you're sort of your senior hires and you're thinking about awarding them any equity in the company, it's definitely important to speak to someone who can give you a bit of expert legal advice, basically to make sure that you protect yourself. Whether it's a share option agreement or a pretty robust co-founder or shareholder agreement. You want to make sure that there are good vesting schedules, leaver provisions, the kind of things that will protect you if that relationship then ends up breaking down, and you don't want that person, that co-founder or a senior employee, walking away with a large chunk of equity that you inadvertently, contractually, basically just gave them.
This is a really good one, because obviously, as we work with a lot of startups and businesses, we've heard lots of different stories about the term sheets and how at the end, sometimes some founders can even end up with nothing from their company.
Yeah.
What would you say is your craziest story of like the term sheet that somebody has signed or almost signed?
I've seen a few sort of horror stories in not just in term sheets, but also in the kind of investment documents themselves, where some investors have been a little bit harsh in terms of their anti-dilution protection, and the founders themselves haven't necessarily understood what that's meant, and so they've either gone ahead and signed the term sheet, or maybe even gone so far as to sort of close the funding round, and so they've signed up to the new shareholders agreement, the new articles of association, whatever it might be. I've seen a few provisions along those lines where a particular early stage investor might have some sort of anti-dilution protection that says, up until the company raises X amount, whether it's, 10 mil, 15 mil, whatever it might be, we, the investor, have a guaranteed shareholding of X percentage. And so that effectively means that for every additional investment up to whatever this threshold is, that investor gets top up equity to keep their percentage equity, their percentage shareholding maintained, even if that particular investor isn't required to put in any more money. Those kinds of anti-dilution protections are really investor friendly and really harsh on the company. And so definitely, if we see anything like that in the term sheet, we step in and very strongly encourage a founder to push back if they can. I mean, listen, sometimes commercially, a founder is a little bit on the ropes, and if they really need the money and these are the only terms that a particular investor is willing to offer them, then it might be that that's just what they have to say yes to in order to kind of allow their company to survive. But where possible, we'd like to hope that we can kind of come up with a more sort of commercially viable sort of compromise position that doesn't kind of tie the hands of the founder too unfairly.
Yeah, absolutely. Any other gems like that to watch out for?
Another key one that we definitely see quite a lot of, and this kind of comes back a little bit more to the sort of co-founder or senior employee type situation, is where you're bringing in another team member, and in the conversation you make a promise to them of X percent of equity, and if you don't necessarily or don't make it clear that, first of all, that equity is going to be subject to any kind of vesting provisions or any leaver provisions. And also, if you don't make it clear that that equity is going to be subject to any kind of dilution, you could end up in a similar situation where, if you're doing a future funding round, depending on what the terms are, whatever you signed in the offer letter, or even just the back and forth email with this co-founder or senior hire, you might end up in a situation where they have an argument that they are entitled to free top-up equity to maintain this promised percentage. Or even worse, it might get to the stage where you have to get rid of them. It's not working out, or they're leaving, and they get to walk away with the full, 5% or whatever it was that you promised them in the first place. And that can happen even after a very short space of time if you don't have an adequate kind of vesting schedule in place. The typical kind of vesting schedule that we see time and time again is 4-year vesting with a 1-year cliff. And that cliff is really crucial because that's essentially the sort of the 12-month period where both parties basically get to kind of try each other on for size. And if the relationship isn't working out, then you part company and the person who's leaving isn't walking away with any of your equity. And I think that that's really important because founders can end up, and this is definitely something that we see a lot as well. Sorry, I'm segueing a little bit here, but
it's great.
We see founders giving away too much equity too early on because they don't really understand what are sort of market standard dilution percentages, and also they don't really understand where they themselves need to maintain a percentage shareholding for their own sort of sufficient stake in the company. The founder themselves doesn't want to get diluted down to so low that they basically lose interest. But also you don't want to be giving away too much equity to particularly people like, very early stage advisors, or maybe coders or software developers in the very beginning where you don't have cash, so you can't pay them a salary or remuneration. So you award them shares instead. And then you can end up having this sort of skewed cap table where someone who was maybe only involved, maybe they did your logo and branding at the very, very beginning, and they haven't worked with you for years, but yet they're still sitting on 2 or 3% equity of your company. So yeah, those are the kinds of errors that we sometimes see founders making, and it can come about because, maybe they've just been misadvised, or maybe they haven't sought advice at the right time.
Hey guys, we're really hoping that you're enjoying this episode so far. And if you are, please like, subscribe and follow. And if you really want to know more about who we are and what we do, go to buildinggreattech.com. Now let's go back to the episode.
And what does that is there a sort of standard, whatever that could be, of how that should be sort of divvied up across the stages? Obviously that's going to depend on the situation, but is there a rough benchmark?
Sure. No, you're absolutely right. It depends on the situation, but there's definitely a kind of rule of thumb. And I would say typically for any kind of whether it's a non-exec director, advisor, or a member of the senior leadership team, basically anyone who's sort of, getting equity for their role in the company, they shouldn't be getting more than 1% at the very beginning. And maybe if they become, first of all, if they stick around, that's crucial. And also then if they become, really senior, really invaluable, and you become aware that you need to be offering them more to incentivize them, then you can consider offering them top-up equity as part of the next funding round. But yeah, as a rule of thumb, I would say the whole directors and senior leadership team, they probably shouldn't hold more than 5% of equity. And then the more general employee population, if you are going to have a share option plan in place for all of your employees, then you probably don't really want that option pool accounting for more than 10, maybe maximum 15% when you're at the sort of seed Series A stage. How much equity you should give away really is sort of how long is a piece of string, and it very much does depend on what's your employee headcount, and also what are your sort of headcount growth plans, because a lot of companies can become very successful very quickly with just a very small number of employees. So you don't want to be giving away too much, if you're only going to end up being, a team of 10. But likewise, if you do only keep as a team of 10, maybe it's fair that actually, the equity is spread out a little bit more fairly than just 9 people having 1% each and the founder sitting on 91%.
Yeah, absolutely.
Yeah, it's very interesting because recently we had some kind of these conversations with a couple of companies about shares and us being advisors, and that was an endless conversation. I don't think we got anywhere in the end, because it's really hard to work out, and it's from both sides. People on one side feel like they need more shares because they're so important, that bring so much value, and on the startup side, obviously they worry they're gonna give away too much shares. So it's kind of pulling both directions, and I get that it's very kind of difficult conversation to be had.
Yeah, there are some quite good resources actually. Just if if there are founders who are listening, I think it's Carta, which is a really great online equity management platform, and they publish reports with sort of like snapshots of all of the kind of users across their platform, obviously on an anonymized basis, but they will provide examples of what sort of like option pools exist for companies at certain places in the journey, and what sort of equity awards they typically see being awarded to, whether it's like C-suite executives or directors, non-exec directors, advisors, etc. So yeah, you can get some guidance like across the board from some of those types of platforms and report providers.
Yeah, do you say Carters?
Yeah, Carta. Yeah, exactly.
Carter. Yeah,
So
I've seen them.
Carta is a US outfit, and they were originally in the UK under the name CapDesk, and then they were acquired by Carta a few years ago. So CapDesk and or Carta, they're one and the same now.
Got you. Yeah, awesome. That's great. That's really helpful, I think. And then you can actually
see some examples.
Get a lay of the market, I guess, if you're like totally fresh.
Yeah, they publish some really useful information about sort of equity and cap tables. Yeah, exactly as you say, across the market.
Yeah.
And what about the intellectual property in the actual startups? Because that's always like, I'm always fascinated, especially in tech space. Let's say I am a founder and I have an idea of how to do something, but I don't have technical skills. What if I get a technical co-founder and that person builds that? Like, who owns the IP? Like, how does it work?
Yeah, it's such a great question. And again, it's a real sort of like issue that founders can sometimes they can fall into a bit of a pitfall with it. So I guess the first thing to note is IP, whether it's sort of like coding software or again coming up with like logo branding, whatever it might be, it belongs to the person who creates it. However, I would caveat that very strongly with, under UK employment law, if you create any IP in the course of your employment, then the IP belongs to your employer. And so effectively what that means in practice is, if you're a founder and you come up with an idea and maybe you yourself create some of the very early stage IP, that IP just belongs to you personally. And it's not until you then set up your company, or maybe you've already incorporated your company, that you have to assign that IP or transfer the ownership of that IP to your company. And that's certainly something that once you get to sort of maybe you're preparing for an exit, or perhaps you're preparing for your sort of funding rounds where your investors are going to start conducting some due diligence. That's absolutely one of the key questions that they're going to ask, is about the IP ownership, and then not just about the IP that's been created by the founder. And they will often want to see any of those kind of IP assignment agreements or IP transfer agreements backward looking, meaning that any IP that was created before the company was incorporated, because quite often that can be the order of events. They want to make sure that that IP is captured and transferred into the company. And then to your point, Anastasija, about if you then get a coder, a developer, someone, a contractor basically, to create some IP for you, the number one key thing that any companies, any founders must be aware of is that that IP will belong to the contractor, unless you have an IP assignment clause or IP like transfer of ownership clause in whatever contract or document you've signed with that contractor. And again, that is a real issue that we have seen a number of startups, particularly tech startups, sort of fall foul of. You're working with someone, they're a contractor, you've got a good relationship with them, they're responsible for a whole section of your IP, which accounts for a lot of the inherent value of your company. But it's not until you actually get to the point where, maybe you have brought in a lawyer to help you with the due diligence because you're about to do a funding round, that you even uncover this issue, and it becomes apparent that actually your company doesn't even own the IP that you think that you've built. And then, it may all be hunky-dory and you could just go to the developer at that point and ask them to sign an IP assignment agreement, and they do, and you've managed to resolve the issue. And we've certainly done that with a lot of clients, and it can be nice and smooth. But if, for example, maybe that developer doesn't work with you anymore, or perhaps there's been a falling out, you can have some real difficulty trying to get that IP assigned, or maybe not necessarily difficulty, but it can be very costly because they own something that you want to get your hands on.
Oh, wow. I didn't even realize that
No,
was
I
the
didn't
case.
know
It's
that
good to know
either.
that.
That's so fascinating.
Yeah,
So that
IP ownership is huge
okay.
in that kind of contractor relationship. It's a really big, that's I would say one of the biggest red flags in terms of developing any IP or any tech, is making sure that it's the company that actually owns it, and you can only make sure of that by having robust IP assignment clauses in place in the relevant contracts.
In the like agreement about the contract, the kind of like statement of work, that work
Exactly.
that is
So
done is for the
yeah,
company. Yeah. But I
yeah.
see
So
what you're
whoever that
saying.
contractor is, what, you have a contract with them that says that they agree. I mean, it might just be a straight IP assignment agreement. Basically, it just says that they agree that whatever IP they've created for your business, they assign it. They transfer the ownership of it to your business.
Okay.
Or it might be that provision is folded into a sort of a wider contract, which is, you, the contractor, agree to build this for us, and you're going to, work for us for however many days or whatever it might be. We're going to pay you this amount. We've got, confidentiality provisions in there. We've maybe got perhaps some exclusivity or non-compete provisions in there as well. And then you've got the IP provisions in that sort of wider contract. But either way, you definitely want to make sure that whoever is building your IP has signed something to say that they are transferring the ownership of that IP to you as well.
Wow. I mean, that's like a gold mine to just know that. I just thinking about, wow, because you said, depending on where they are in the journey, like you can
Yeah,
see how so easily that might happen further up the chain. It's just like, oh, can you help me out with this?
absolutely.
Friends, buds, and then, wow,
Yeah, I mean, we see, like, there are some, particularly now in the age of AI, where a lot of like really sophisticated tech is getting built very quickly and gaining a lot of traction, a lot of high value without necessarily having to bring in investors. And so a lot of these companies that might have been, kind of very early stage bootstrap companies are kind of going stratospheric without necessarily bringing in, whether it's the investors or the lawyers or anyone with that kind of legal expertise at those early stages. And then you're almost getting to exit by the point at which someone says, "Oh, hold on a minute, who owns this IP?"
Yeah, no, great. So, is the Chat GTP contract worth anything in court?
Great question. Yes and no, I think, is the simple answer. I would say, I mean, listen, for sure, founders are, they're turning to AI for help with their legals. Founders are very clever. AI is extremely quick and it's really cheap. So there's certainly no reason why, they wouldn't think that actually they could just kind of DIY it with the help of AI. AI contracts, yes, they do stand up in court, assuming that the drafting of them is clear enough that there's nothing ambiguous. I mean, sometimes, and this is kind of one of the reasons why I would say, AI is great as a starting point, but you probably still need to at least consult a lawyer at some point before, just get final sign off. And the reason for that is, if you're, going to ask ChatGPT or whatever to draft a contract for you, you might not necessarily have enough expertise in those kinds of contracts to be able to spot where there's any sort of misdrafting, ambiguity, or conflicts in the drafting. And those are the kinds of issues that can either make the drafting lopsided, not in your favor, for example, or even worse, make the drafting kind of so ambiguous or with so many kind of conflicts in the terms throughout the document that it ends up being unenforceable. Sometimes we see documents that they just don't make sense because in clause 1 it says this and then clause 13 it directly contradicts it, and you then end up in a situation where it's not clear what the contract is trying to achieve. And so yeah, I mean, for sure, AI is absolutely great, and there's I think it's great that clients, founders, companies are trying to kind of certainly use AI to educate themselves in legal principles and legal concepts. I think that makes life for lawyers a lot easier when you then have a client come to you and say, I understand this and I've read around this, or I've researched the headline issues on this, or maybe even I've used ChatGPT to prepare this sort of first draft of this document. But I also recognize that I probably need, a bit of human legal expertise to just give it the once over, tell me if I've missed anything crucial, and then give it the sign off.
Yeah, I think that's such an important point there, is like there's a bit of blindness unless you're a kind of
Yeah,
specialist in a field.
that's exactly it. You don't know what you don't know.
Yeah, exactly. It's so kind of convincing. I could tell a
Oh yeah,
story
God.
where I might. I actually did use it once myself, to sort of review a NDA, and
Mhm.
yeah, it made some suggestions, and I sent that back. The guys were like really accommodating, and I thought that it seemed like reasonable what it was kind of pulling out around the terms.
Mhm.
And then they went off and kind of chatted with the lawyers, and they said, no, just leave it as is. So I kind of learned my lesson that, yeah, I mean, like we
I
use
mean,
it ourselves. Go on, go for
yeah,
it.
as does everybody. I think like you'd be a philistine if you were trying to tell clients to not use AI, or to
Yeah,
try and sort of like represent that actually AI is not helpful in, like, preparing legal docs or reviewing legal docs. It's just simply not the case. And we use it as well. Our team, we're increasingly using it. It's so helpful in sort of that quick first review, or even that quick first draft. But it's then that sort of the layer on top, which is the human expertise,
yeah,
and whether that's just like the depth and breadth of knowledge of the particular subject, or it's the sort of the commercial nuance, or the market understanding. And it's all those like extra pieces that get woven together that mean that, yeah, ChatGPT is great, but you kind of can end up missing some things, and then you don't even know that you've missed them.
context.
Context.
Yeah, we
Yeah.
have we have
Hmm.
And also AI makes it sound like it's true.
that.
Like
Oh,
it's
it's so convincing. It's
it's
so
so
articulate.
convincing, even if it doesn't make any
Yeah.
sense. Like I was even looking randomly at some numbers. Like it was just literally simple calculation of percentages, and it was giving me wrong numbers. And I was like, "This is not the right number." Like, so I asked him, "Are you sure you're giving me the right number?" And he said, "Yes." And then in the same sentence said no. Like it's just so weird, because it's just kind of like, but it makes you feel like it does know everything, but it doesn't, right? So
Yeah, yeah,
we use it.
exactly. It really
Yeah,
convinces you.
you convinced you, and we
But I
use
think,
it.
I mean,
Go on. Sorry.
sorry, I was just going to say, Anastasia, like absolutely without a doubt, where the stakes are low, maybe the document itself is sort of like of relatively maybe low value, or it's an internal document. Things like, I don't know, a job description or some of your internal policies. Definitely use AI. I mean, it'll do a great job. It'll take a lot of the heavy lifting out of it for
Yeah.
you. You I mean, you don't need to be asking a lawyer to help you with those kinds of things. But when the stakes are much higher, or when the drafting is a bit more complex, or in particular, when you're then sort of looking at anything that's kind of like fairly like regulatory heavy or legislation dependent, I think at that point, then yes, AI can kind of be used as the starting point, but you probably then need to bring a lawyer in. And examples of that are when you're negotiating your documents with your investor, or maybe even like, for example, you're putting in place a share option scheme, and you've used AI to help you understand what vesting and leaver provisions actually mean, but then to draft them, yeah, maybe that does the first cut for you, but a lawyer should probably do the final review.
And yeah, and now we're talking about like general chat GPT kind of a Claude level, right? But what about
Mm.
specialized tools, AI tools like Harvey, for instance? I think it's
Yeah,
supposed to be like
I
quite
mean,
amazing. I don't know if you have a chance to look at it or heard of it.
they're really great tools, and I've like kind of played around with some of those. There's a lot of really helpful legal AI tools on the market. I think what I would say about those kinds of tools, Harvey's a great example, and Lane's another great example. They are specifically designed for very high volume, very dense, complex contract review and contract drafting, and they're sort of, I mean, I don't know off the top of my head, but I imagine they're not cheap tools. So they're not really designed for early stage companies to just do their own sort of like basic drafting. But again, they they are a little bit more specialist, but I guess they sort of still have the same sort of drawbacks, which is you don't if you're not able to ask it exactly the right sort of prompt and put in the right kind of information in the beginning, then you won't be able to spot where it has produced something that is sort of slightly skewed or maybe kind of gone off in a slightly wrong direction, because you won't necessarily understand the error in your own input or your own prompt.
And who is kind of because I understand if somebody uses ChatGPT to create a contract, obviously OpenAI is not going to be liable for anything.
Absolutely not.
But what about like if you have specialized tools like Harvey, who is then liable if it produces like bad output?
It's a great question. I actually don't know. I haven't sort of gone into the T's and C's of Harvey well enough to understand, but I would make a sort of a fairly educated guess that they would have a lot of disclaimers in there that say, we can help you. Like the tool is designed to sort of produce, like well-informed drafts, but it's not designed to be actual reliable legal advice. I mean, legal advice that you can stand behind, or indeed that you can kind of bring a claim against your lawyers for. That's why we have pretty expensive professional indemnity insurance. And I'm not sure that you would necessarily be able to sue Harvey for that. I mean, the thing with contracts and their enforceability, a contract can just be a conversation or a sort of an email or a WhatsApp exchange between two people. It doesn't actually, in order for it to be a legally binding contract, it's certainly in the UK, it doesn't need to be drafted with any degree of formality or sort of like a specific complex drafting. But of course, the question about whether it's enforceable will come down to sort of certain contractual principles. Was there a contract there in the first place? But I think the bigger issues with using ChatGPT in kind of like a legal setting are more around, for example, and this is certainly, I mean, we sort of see these like headlines in the news where the AI tool is hallucinating, and then maybe sort of, for example, it brings in kind of made up case law to support a particular argument or whatever that might be. And in that scenario, and I think, we've certainly seen these, judges really do not look favorably on lawyers who are cutting corners and using AI tools and then not checking the work and, submitting sort of legal documents with, just made up stuff in them. But they've just sort of allowed, whether it be Harvey or whatever AI tool to draft. They are incredibly useful, and I think they really are, I mean, across all industries, not just the legal industry, but they're really revolutionizing how we work and how quick we work, and also making what has maybe otherwise seemed like kind of a sort of like slightly impenetrable industry a lot more accessible to a lot more people. But at the same time, you do still need a lawyer to stand behind it.
And Gretchen, I really wanted to ask you, because you mentioned you worked, in the city here in London. What made you want to go and work with startups instead?
I think it actually kind of, it came about sort of quite by accident. I think I had been working at Latham & Watkins, which is a great law firm, one of the world's biggest law firms, and I had been in their London office for maybe 6 or 7 years, working on some like really high value transactions with huge clients. It's all very exciting, very glamorous, but just long hours, and it's tough work. And I took some time out to just really just kind of like step back and reflect and have a think about what I wanted to do. Very much, and when I say I took some time out, I came to Verbier to do a ski season in the Swiss Alps, very much intending that after the sort of the 5-month season, I would return to London, get a new job at maybe another law firm or perhaps go in-house. And during my time out here in Switzerland, I sort of fell into conversation with a few different people. I met someone who was working as a legal consultant and felt quite inspired by her journey. I then also spoke with someone who the company that he was running was about to undergo a redundancy exercise, and my background was employment law. And he had an in-house legal team, but they were primarily commercial lawyers, so they didn't really have a sort of in-house employment law specialist. And he asked if I'd be interested in coming and doing a sort of like I think at the time it was like a 6-week stint to just kind of guide them through this one particular redundancy process. And so that kind of opened my eyes to the sort of world of legal consultancy, kind of, basically like kind of essentially like sort of fractional GC work, I guess we would call it now, but on a much smaller scale and on a much more sort of concentrated scale at that initial time. And so that kind of gave me the confidence or the encouragement to then set about like becoming self-employed, and as I say, yeah, getting my own professional indemnity insurance, getting my own company set up, and then from there, just very slowly and gradually building my client base, and then also building out my team, and making the transition from working with large clients, working through a very, very large law firm and working with huge international clients, to then pivoting to working almost at the sort of the opposite end of the kind of company life cycle with, startups and solo founders and so on. I found it really rewarding, because you get to kind of very quickly form a relationship of trust with your clients, and they, you get to become a bit of an extension of their team, in a much more kind of like cohesive way than maybe just working as a big firm. You're so far removed from the kind of the key decision makers, I guess, as it were. Whereas when you're working with startups, you're working sort of hand in glove with those key decision makers, and then you get to have quite a lot of sort of input from a commercial perspective as well. You're not just advising on, well, this is what the law says, and sending a sort of 10-page memo on these are all the points for consideration, and then but you could do either this or this. You actually get to make a kind of a much clearer judgment call, and provide much clearer advice, and also be part of the sort of the early stage growth journey, which is a lot more exciting, or at least for me it is.
And yeah, that sounds lovely. Like a bit more human. You've got
yeah, exactly that. You have a lot more of a human connection with
yeah,
people who are working really hard to build really exciting companies.
yeah, changing things. That's
And
really exciting. I've
yes,
got
Yeah.
one quick question. And the differences between London and Switzerland, is it just the mountains on your doorstep, or are there other pros?
I mean, yes, for sure. Like, waking up to a view of the mountains is pretty special. I think, I mean, don't get me wrong, I miss London and I love to come back, and it's, really nice to sort of dip in and meet clients and catch up with friends and so on. And it's also really exciting to be like back in the hustle and bustle of the city every now and again. But I mean, it sounds so old, but I've really enjoyed stepping out of city life and just enjoying a much like quieter, calmer, more like in nature lifestyle. I mean, COVID was awful for so many reasons and for so many people, but one of the things that I really benefited from as a result of COVID was the way in which the whole world kind of like pivoted towards and really got a much clearer understanding of remote working. And it also meant that actually growing my team off the back of that period was a lot easier, because I think a lot of other lawyers and lots of people in general, but lawyers in particular for me, were more open to exploring becoming a remote worker or becoming a kind of a fractional like legal consultant type worker. So yeah, I mean, London's great, but it's very nice to be able to work fully remotely, and run the business from the mountains for sure.
Yeah, I love that.
No, I love it. And what would, because you said it was amazing to switching obviously from these big firms to smaller startups, but I would love to know, like, what was the most challenging for you, like in that transition and running your own business?
The loneliness, I think. It was a huge transition to go from being part of such an enormous company, a big law firm, just like a team within a department, within a huge office, within a global firm, and all of the support staff around it, and all of the infrastructure that comes with that. You've got like the IT department and the print room, and like there's so much that's sort of like done for you, and then to become a one-man band, and not only do you have to very quickly figure out how to do all of your own sort of support work, you have to figure out how to do all your own invoicing, all your own IT. That's a work in progress. You like also, your marketing, you're sort of, you have to learn a whole lot of different skills. But I think the loneliness, at least for me, and it's a lot better now, I've grown the team and now I work much more closely with other lawyers. But it was the idea that you suddenly had to be able to like make judgment calls and stand behind your own decisions like completely and with confidence, but without having, other sort of colleagues or supervisors or, sort of senior associates or partners to provide that encouragement or, even just kind of act as a sounding board. So yeah, it was definitely a transition to suddenly be like, oh wow, okay, I'm out here on my own and I'm doing it. But like that was one of the toughest parts, but that was very much kind of, a trade-off for or sort of an easy price to pay, I think, for having so much flexibility and freedom and autonomy, and also getting to work with much, I don't want to say easier clients, but clients that are a lot certainly a lot more responsive and a lot more grateful for the help that you can offer them.
Interesting.
Very interesting.
Yeah, humbling, isn't it? I think going from
definitely.
Yeah. You realize how much actually work is being done for you.
Yeah,
those big companies.
Oh God, yeah. And how much you rely on all of those like behind the scenes teams when you're in a large organization and everything just works seamlessly.
Yeah.
You have a sort of a tech problem and IT just remotes in and sorts it for you, or you have I don't know. I mean, even like you go to the little kitchenette and it's always stocked with tea and coffee, and then you're like, oh.
Amazing. Cool. Gretchen, I love this conversation. If you were to give one piece of legal advice to founders, what would be your sort of top thing that you would say?
That is a great question. I would say don't be intimidated or overwhelmed with what you perceive working with lawyers to be like, because there is this whole new generation, and I'd like to think that Lennon Legal is part of it, of sort of working with lawyers that is not just working with these like sort of stuffy old men in big offices, and don't let that kind of conception of what it would be like to work with lawyers, and indeed how expensive they are, because we're really not. Don't let that hold you back from maybe reaching out and thinking about getting legal advice sooner rather than later. Not least because you will absolutely save yourself a huge amount of sort of cost and headache further down the line if you get things right from the beginning, as opposed to trying to unpick issues at a later stage. And that can be in relation to as I said, a co-founder agreement. That's a crucial one. Whether you're speaking to investors and your IP ownership as well. So yeah, reach out sooner rather than later.
That's great.
Awesome. Gretchen, if somebody, any of our listeners or people watching this, if they wanted to reach out to you and connect with you, how can they best do that?
Sure. I mean, they can email direct hello@lennonlegal.com, or there's a contact us form on our website, which is also lennonlegal.com, or you can find me, Gretchen Lennon, on LinkedIn. So yeah, contact us any way you like.
Amazing.
Perfect.
Do you have any other questions?
No, it's amazing. Yeah. Thank
awesome.
You so much.
No, I actually have a final question. What do you think is going to happen? Let's say it's 2030 or even like 2040. Hopefully we're still all alive. What do you think is going to happen with the legal space and AI? Like, what's your prediction? Is it going to be taken over, or is it still going to be like nobody knows what's going on?
I think it's a really good question, and I think we will probably see a lot of the sort of more junior roles and maybe more like kind of company secretarial, paralegal type roles perhaps being replaced with AI tools. But I think that we will definitely see a shift towards lawyers being valued for their kind of, as I said, their sort of their depth of knowledge and their commercial nuance and experience over and above just their sort of, like straight drafting or straight reviewing, because those are the kinds of things that AI tools are only going to get better and better at. So yeah, we might see a sort of shift in direction and maybe even a shrinking of the legal industry in terms of headcount. But the lawyers that are there in 2030 or 2040, they will be valued much more for their kind of high level and sort of commercial input and market knowledge input than just their sort of yeah, they're drafting lengthy documents.
I was going to ask actually, what's the structure of your team? Have you got, because you got 10 people under you, are they all similar areas of expertise, or you specialize? How's that kind of break up?
So it's a bit of a range. So the team advises across sort of corporate, commercial, employment, data protection, loan finance, and corporate governance. So we've got members of the team who sort of specialize in all of these different areas. So we've got a couple of employment lawyers and share option schemes experts. We've got a few corporate law experts who specialize in funding rounds or exits or other M&A transactions. We've got a few who are commercial contracts experts. So they do a lot of license agreements, SaaS agreements, your website T's and C's. We've got a great data protection expert. He's a real GDPR nerd, but I think you have to be if you're going to be an expert in that area. And we've got another great lawyer in the team who specializes in sort of like banking and debt finance. So if you're raising finance through loans, then she's the expert on that.
Amazing. That's really cool. So it's like almost a full 360 offering you've got for your clients.
Yeah. I mean, I would definitely caveat that we don't have anyone on the team who does commercial real estate, but it's not that often that startups are sort of buying and selling commercial property or negotiating long leases. I mean, some are, but and we also don't have an IP expert on the team, but we do work quite closely with another firm who are specific startup IP experts. So if you want your sort of trademark protected or anything like that, we know exactly where to steer you.
Yeah, and on the GDPR point that you just mentioned then, I was thinking, like, how much change happened post Brexit? Did that impact your work a lot, or
it did? I mean, there was a bit of a transition period, but the UK GDPR, so the UK legislation that was brought in, quite closely mirrors the European GDPR. So Brexit didn't have a huge impact on that particular area, and indeed there was quite a lot of work done by the UK government to try and make sure that the UK legislation aligned with the requirements of the European legislation, so that actually it would allow for as smooth a transfer of data between companies in the UK and companies operating in the EU as possible, because otherwise they would end up being what's called a third country or third. So you have that sort of like the US or other jurisdictions where for certain jurisdictions, their data protection regime is not viewed by the European Union or the UK as protective enough. And so there have to be certain types of contracts in place before any personal data can be transferred to companies in those jurisdictions. So, as far as kind of the alignment between the UK and the EU goes for GDPR, we're fairly closely aligned, which has made that post-Brexit transition a little bit easier. But I mean, there were certainly lots of other changes, and I'm sure there are still sort of changes to come. But GDPR, I think it's certainly an area that if your company is dealing with quite a lot of personal data, whether that's because you've got enormous sort of customer databases or maybe a lot of sensitive personal data, then you want to make sure that you have consulted an expert and you've got your finger on the pulse really when it comes to that. But for a lot of startups, maybe particularly in the tech space where they're not really actually kind of dealing with that much personal data, it's not an area you need to get too worried about, and it's not an area that you need to spend too much money on, I would say. It's worth having someone kind of give you a bit of advice, but don't get too bogged down on it if you're not dealing with a lot of personal data.
Okay, we've got a good one we missed there. Okay. When can a VC legally fire a founder from their own company?
Oh, that's a really good question, and we definitely do see it. So it is not unusual for VCs to ask for board seats when they invest in a company. And then, so the board can fire, the board is the sort of the board of directors are the decision makers and the representatives of the company. And so the company can fire anyone really. And so there have certainly been occasions where perhaps because the kind of makeup of the board and who the VCs are, and maybe however many board seats they have, and perhaps who else on the board they managed to get on their side, whether there are other non-executive directors or perhaps even other founders who are also on the board as well. A majority of the board can make a decision to terminate the employment of, terminate the relationship of any other board member and indeed any founder. And then that means that the founder's employment would be terminated, so they would no longer be the CEO, the CTO, whatever their job is. And then what happens to their, and they would also lose their board seat typically. The board would have voted them off. And then what happens to their equity entirely depends on the leaver provisions that are in their relevant documents. But if this has happened, and it's happened because there's a VC on the board or a number of VCs on the board, a number of investors, I should say, I would say that it is highly likely, not definite, but highly likely that when those investors came into the company, they probably also would have renegotiated the shareholders agreement or the articles to introduce founder vesting, which effectively means that the founder's own equity becomes subject to a vesting schedule. And so therefore, depending on the circumstances of the founder's departure, whether they're a good or a bad leaver, they may end up losing quite a large chunk of their equity, or perhaps even all of it if they are voted off as a bad leaver. So yeah, when you are bringing in VC investors, there are lots of things to look out for, but certainly the terms that they are trying to impose around founder vesting and the leaver provisions attached to those are really important to understand. And then also it's really important to understand the makeup of the board and who your allies on the board are. I mean, it's when the investors are coming in, everyone's great friends and everyone's on the same page and very excited for the company to move forward. So it's hard to tell, where the little cracks might appear in the future. But you certainly don't want to be in a position where you're a solo founder on the board and you bring in 2 investor directors and then you're kind of outnumbered. Ideally, in that scenario, you would bring in at least one friendly non-exec director who can kind of be in your corner a little bit more.
Fascinating. And what size, does the company need to be in order to actually kind of implement a board? How big? I sort of equate it normally to a bigger corporate kind of enterprise level. They've got big boards and compliance and due diligence and stuff. But yeah, I wonder how far down the chain that actually goes for the founder world.
For smaller companies, I mean, so a board is really nothing more than just the collective term of directors. So if you have more than one, technically, I suppose if you have a director, they are the sole director on the board. But once you have more than one director of your company, that's your board of directors, those 2 people. In the UK, all UK companies have to have at least one individual as their director. So I guess technically every single UK company has a board, even though can be just one person.
Wow.
But when in terms of, I think more to your question about actual kind of governance and what is an appropriate size of your board, really typically for companies that have kind of more than one founder, so 2 or 3 co-founders, it's not unusual for all 3 of those or all 2 of those to be appointed to the board. Then as the company grows and you bring in more institutional investors, so VC investors or other types of maybe you might even get to sort of PE investors, it's not uncommon for those investors to each ask for a board seat or maybe even 2. The other sort of type of board directors that you quite often see in early stage companies are non-executive directors. So people who sit on the board but don't work in the company day to day, they just attend the board meetings. And whether they're an actual non-executive director or whether they're just a board advisor, they kind of can fulfill the same sort of role. But as a board advisor, they don't actually have any personal responsibility or liability for the actions of the company. But as a non-executive director, they are a director in the eyes of the law. And so they do have they are part of the collective of directors who have personal responsibility and liability for the actions of the company.
Fascinating. Yeah, that's really good to know.
We could continue for another 2 hours with you, Gretchen. It's so easy to talk to.
Yeah. Thank you. I've really enjoyed this chat. It's really great to sort of explore the different legal issues and kind of pitfalls that founders can sometimes encounter.
Yeah,
But sadly, we'll have to kind of come to an end.
No, but hopefully it makes the point that it's worth, seeking out legal advice sooner rather than later, right? The sooner the better.
I think that's the sooner the better. But at the same time, like from the very beginning, like with a co-founder relationship, get a good co-founder agreement in place. But if it's just you and you're setting up your own company and you're totally bootstrapped, I mean, I don't want to sort of, undermine my career, but you can probably get fairly far before you actually have to start thinking about incurring legal fees.
Yeah, but it seems like even if with all of this AI stuff and help from AI, it seemed like if you're not doing it right and if you don't have any advice from actual proper lawyers, it seems like you might be sitting on a ticking bomb for the future.
Yeah, and we have definitely seen a few of those, unfortunately.
Going off.
So going off, exactly. And going off in a way that ends up costing founders, a large chunk of their company that they weren't expecting to have to give away, or a lot of money to buy back portions of their company that they didn't expect to have to do, or to buy their IP that they thought they already owned.
Yeah, amazing. All right, well, Gretchen, absolute pleasure talking to you today. Hopefully we'll speak again on more details.
I'd love that.
But that was such a pleasure. Thank you so much for dialing in today.
Yeah, thanks so much for having me. Really enjoyed it.